Hey everybody, John Skiba here, and in this video I'm going to talk about some of the most commonly asked questions that I have received ever since I put out the video on how to win your debt collection lawsuit by compelling private arbitration. So stick around, I'm going to go over the top 3 questions that I get on how to compel private arbitration if you're being sued by a junk debt buyer. But if this is your first time here to my YouTube channel, go ahead and click subscribe. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right. Let's talk about private arbitration. I put this video out a couple of months ago on ways to win your debt collection lawsuit, particularly if you're being sued by a junk debt buyer like Midland Funding, Portfolio Recovery. I put out the video on how you can win your case by invoking a clause that the original creditor had in the terms and conditions of the credit card, namely the private arbitration clause. So as a backdrop to it, and I'll put a link to this video down in the notes to this as well, so you can go back and watch that one. But essentially what it is in pretty much all older credit cards, there's in the terms and conditions, there's what's called an arbitration clause. The arbitration clause allows either party to have disputes submitted to private arbitration. Private arbitration is essentially where you're hiring a court or hiring a judge. It's not the actual judicial court system that's run by the government, but these are private companies like the American Arbitration Association. JAMS is the other one that's typically used, where you can actually hire them and they'll resolve your dispute for you, and it's binding on the parties. Now, this term was written to be a benefit to the creditor. However, you can use that and compel arbitration against the junk debt buyer or even the original creditor themselves and force the matter out of court into arbitration and have an arbitrator deal with it. Now I can tell you in a lot of cases, the debt buyers and the original creditors, they do not want to go to arbitration because it's extremely expensive. It can cost thousands of dollars for the creditor to file the case there rather than going through a local court process. And so that's not where they want to be. And so many times when you get the court that they filed the lawsuit in to force the parties to go through private arbitration and essentially adhere to the terms of their contract, they'll just dismiss the case because it's not worth it financially for them to go through that process. Not only that, it's out of the wheelhouse of what they do. They have a system set up, how to process huge volumes of debt collection cases, and you're throwing a wrench into it by requesting it to go through private arbitration. So I put this video out a few months ago, have had a lot of questions about it. I also put out an online tutorial that walks you through it. I have a template in Word format so you can tailor it to your specific situation. I'll put a link down to that as well so you can check that out. But let's talk about the 3 things that I hear most in the feedback and comments and from people reaching out to me on what this process is like. The first thing is timing. They want to know, okay, that's great, but I already filed an answer to the lawsuit. We're heading towards trial. Is it too late? In most cases, the answer is no, it's not too late. You can file a request for arbitration as the initial thing you file right after you get served with the complaint and the summons. Usually you're going to draft an answer and file that with the court. Instead, you can file a motion to dismiss and compel private arbitration. But if you filed an answer instead, that's fine. Most of those arbitration agreements, if you go back and look at them, they state that either party can ask that it be submitted to arbitration as long as a judgment hasn't been entered, or sometimes it'll say as long as trial hasn't been, the trial actually hasn't started. So in most cases, even if you filed an answer and even if you're well into the case, as long as the judgment hasn't been entered against you already, and as long as you're not actually in trial, you can invoke that arbitration clause and get the thing kicked out of court and into private arbitration, and hopefully just done with at that point. The next question is kind of similar. What is the procedure for being able to do this? The procedure is you have to file a written request with the court and have them compel arbitration. Now, I have done this one of 2 ways. It's usually done through what's called a written motion. So you can file a motion to compel private arbitration and ask the court to dismiss the case and force the parties into private arbitration. So you can file a motion to compel and dismiss, Or sometimes what the court will do is they'll have you file a motion to compel and stay the court case, meaning stopping or putting on pause, on hold, while the matter goes through private arbitration. Either way, it's a motion to compel private arbitration. Again, in the online tutorial that I put together, I do have a template that you can that has the framework there, and you can use that to draft your own motion and submit it to the court. So you file a motion to compel private arbitration, file with the court. You're going to provide a copy to the other side, to the other attorney, and then they have an opportunity to respond to it. In most jurisdictions, you'll then have a chance to reply to it. The court will then either issue a ruling, or the court will set the matter for oral argument if they have any questions. But that's generally what the procedure is. In most courts that I've seen, you file the motion to compel arbitration. The other side may respond and object to it. One thing that you have going for you is it's their agreement. They drafted this thing. You're just trying to use the terms that they drafted to kind of hold their feet to the terms that they actually created. So this isn't something you're making up. This is their contract. You're just asking the court to enforce the terms of it. So that's how it's done. It's done through a motion. Third thing that you look at, the question I get from people is small claims. Usually in the arbitration clause, it says that if it's in small claims, the arbitration clause does not apply. That's true. In most jurisdictions, however, if there's an attorney involved, it's not going to be in a small claims court. So look at your local jurisdiction and see, is the case actually in small claims? Like in Arizona, we have a small claims court where there's no attorneys allowed. And so if it was filed there, I know it's not going to be a debt buyer case, because debt buyers all have attorneys. So I hope that helps. Again, check out the notes below for a link to the actual arbitration tutorial that I've put together. It can be a big help. And thanks for watching today.